Yeah, with the separation of the state from religious activities, that's your question. The actual text says, Congress shall make no law respecting an establishment of religion, and then the U.S. Supreme Court has put in or interpreted that to have additional language as to what a government can and cannot do with respect to religion. Prayer in schools, is there really some kind of wall between religion and state, and all those issues. So the text doesn't say a lot of what the U.S. Supreme Court has interpreted to say, but they have interpreted to say that it's there. So a lot of people telling you what the Constitution says actually are telling you what the U.S. Constitution's interpretation of what the Constitution says. That's still the law, because we have the Constitution as interpreted by the U.S. Constitution, by the U.S. Supreme Court. So it is what they say it is. Yes, sir.
Don't we have some of the same issues locally, domestically, with political correctness? Same thing as the cartoons and the Muslim world. We're not really shooting each other, blowing each other up. But what about political correctness? The argument that if somebody makes a speech, somebody else doesn't like it, it's on a university setting, and public forum, they're not going to say.
And then the issue becomes, well, is that protected or not? And would it constitute something that's going to create a breach of peace or not? And those are troubling aspects. So yes, I think it's pertinent. Yes, ma'am.
Thank you for being with us tonight to speak with us. You brought up the case of the cartoon Muhammad. It's interesting, you can't rob somebody of their right to security, so somebody else's right to speech. But at the same time, it's not like the false claim. It is proactive implementation of those. Instead of waiting for somebody to commit a crime and then doing it afterwards. So doesn't like the fall by people who are immediate arrest or who will have carried out the act of violence?
Yeah, if someone is, the issue is, can you hold the First Amendment hostage by threatening to do unlawful life? That's when we get into the difficult constitutional analysis of, well, it's important to protect innocent people. So does that interest in protecting innocent people outweigh the First Amendment right? And those are difficult issues. You intuitively you think, of course, First Amendment protects, and we need to guard it. But under the state of the law, what's the answer going to become? So, as I said, until you have some black letter type legal rulings, and yet those are the kind of rulings you hope you never get, right? Because you hope it never presents itself. But it's very troubling. I'm not sure I answered your question, but did I? I'll try again.
Is the Constitution a living document?
It's a lie! That separates what your basic philosophy is. I think no. I think you have to go back to when it was originally written and determine the original intent. So that's a judicial philosophy question. That's mine. Yes, sir.
Sort of going into the long lines of some of the other questions were asked. The actual language of the First Amendment says that the freedom of speech cannot even be abridged, which implies not even limited, let alone violated. So I guess, what the initial thoughts that the founders have that cases that would be exceptions, I guess, where it could be curtailed?
Well, there are certain categories of speech that fall outside the First Amendment protection, like I talked about, the obscene, libelous, all those, and fighting words that I've talked about, and really sort of the issue of the last hypothetical, also falls outside the scope of of the First Amendment. And so that's because of that, those exceptions, that's the troubling aspect of it. Well, that some of those really difficult situations fall within the exceptions or exclusions from free speech. That's the troubling aspect of it. But there are some categories you can't yell fire in a crowded theater, all the things that you've heard about. So.
They define fighting words as, I guess, like with a direct, threat, sort of, whether it be implied or stated outright, as opposed to something that a person really believes, but someone, because of their beliefs, might find offensive without the intent, to start a fight.
So if I'm to somebody, I'm going to say this, and if you don't like it, I'll meet you out back and we'll take care of it. Is that really got to be your kind of intent? I mean, where you're really going to get into it, with them, or are you content, just to say, well, okay, I'm going to say this. I hope nothing happens, but knowing that something's going to happen because of the historical evidence of violence when somebody's done that. So knowing that, even though you really don't want to have to be the one to get into some kind of fight with them personally, you know it's going to cause that. Is that fine or not?
When threats of violence fall under different laws, such as assault and battery, if you call in and you give a bomb threat, that's not freedom of speech. You threaten somebody,
Yeah, no, you can't have protection of freedom of speech that constitutes a crime. That's not protected speech.
Other laws cover threats or fighting words, depending on the level of the fighting words.
Right. Yes, sir.
Yes, Your Honor. Would you be able to elaborate more on what constitutes obscenity and whether the court applies its own standards of what is or not obscene, or whether it takes into account what the standards are of the community in which the alleged offense occurred?
On obscenity? No. Obscenity is like the famous line, obscenity, you know it when you see it. So there are some extremely, somewhat complex nuances you go through in evaluating obscenity stuff. As you say, the standards of the community, what are the standards? Well, if this obscenity is being broadcast not just your locale, but it's being broadcast statewide or nationwide, what if it's on the internet? What do you look at then? Whose standards are you looking at then? Do you look at where it's broadcast from, where it's viewed from? What if everybody in the state sees it? What if everybody in the nation sees it? So there are a lot of complex issues. So I am prepared to not do that. Somebody? Got one? No? Okay. Anybody? Yes, sir. In the back. How is it?
Any different approach, I see, higher court saying.
I've got the Chief Judge of the First District Court of Appeals, Judge Paul Hawk, sitting here, so I better be careful how I answer. No, I enjoyed my tenure at the First District Court of Appeals very much. I was there almost 8 years. I missed working with my colleagues there at the court. It was a lot of fun. We had a great amount of jurisdiction at that court just across the street. That's the First District Court of Appeal just across the way there in the White Building, if you didn't know that. It's got jurisdiction from the Panhandle. It goes all the way from the Panhandle all the way over to Jacksonville. It goes as far south as Gainesville. It has jurisdiction on circuit court rulings on criminal matters, family law, civil matters, administrative law, and most of the constitutional issues come through that court. And that's because state agencies live here. And state agencies, by common law, are entitled to a home venue privilege, which means that if you sue a state agency, they get to be sued where? They live, in Tallahassee. That's why most of the constitutional issues come through